So my name is Robert Isozaki. I'm a special assistant in the Assessor's Public Affairs Division. The elected assessor is Jeff Prang. Fortunately, he couldn't be here today with you, but we're going to share some important property tax information. So let's get started. So as you can see here, we've got a long
of what their property taxes are going to be. When we come up with that property value, we send it over to the auditor controller's office. They take that value, apply the appropriate tax rate, apply any other what we call direct assessments. Those are things like taxes for emergency services, sewer, mosquito vector control, things like that. And all of that goes into your tax figure.
Now moving on. So how do we do our job? Again, most of you are probably going to be familiar with this. Prop 13 basically says when you purchase a piece of property, we establish a tax base for that property. Oftentimes it's going to be the sales price, not always, but most of the time. There are going to be, every year after that, we can increase that assessed value by 2%. I like to call that your Prop 13 protection. So that means that as a homeowner, if you don't do anything to your property, you don't transfer it, you don't build on it, you're going to see consistent growth. And that means that you're not going to see massive dips and spikes in your property's assessed value and taxes from year to year. But there are certain circumstances where you're going to get pulled out of that Prop 13 protection. That's when there's a change in ownership, like a transfer or sale of the property, or when there's new construction. So I've highlighted here change in ownership because that really is what applies to Prop 19. So what is Prop 19? It's a new law that came on the books in November of 2020. It made substantial changes to two pre-existing property tax benefit programs. So the first, it expanded benefits for property owners who are seniors, to property owners with disabilities, property owners who become victims of natural disasters or wildfires. That came into effect of April 2021. So that expanded those benefits. On the flip side, it restricted benefits that were available for family transfers. So transfers between parents and children, transfers between grandparents and grandchildren. That also came into effect in early 2021. So we'll go through these one at a time. So first, what we call base year value transfers. This is the expanded portion. So basically what it did was, under the old law, you were able, or basically the general concept for this particular part of Prop 19 is, if you are a qualifying homeowner, you can sell your original home, purchase a replacement home, and transfer that original home's low tax base over to the replacement home. Now, how did this Prop 19 expand these benefits? Under the old law, you were only able to do this tax-based transfer program if you purchased a replacement property in about 1 of 10 participating counties. Now this program is available statewide, so you can move anywhere and transfer your tax base over. Under the old law, you were only able to do it one time. Now you're able to do it 3 times. This third point is what I regard as the the greatest expansion under Prop 19. Under the old law, you could only transfer your tax base over to a replacement property that was of equal or lesser value than the original property that you sold. Now, it doesn't matter. It can be equal, lesser, or of greater value. The caveat, though, is if you upgrade, you purchase a property that is worth more than you sold your original property for, we're going to take the difference in market value, difference in sale and purchase price, and we're going to tack it on to the tax base that you move over from your original to your replacement property. So that makes sense. Not a change in the law, but something that's very important for property owners that are looking to take advantage of this program. The sale of your original property and the purchase of your replacement property, those two transactions have to occur within 2 years of one another. Doesn't matter if you sell first or purchase first, they just have to happen within 2 years. If you don't, unfortunately, that property owner is not going to be able to avail themselves of this particular program. Now, you'll see down at the bottom here, it says SB 989. That stands for Senate Bill 989. That law was enacted within the last year, and it was meant to address the backlogs that our office and other assessors' offices across the state are experiencing in processing these Proposition 19 base year value transfer program claims. So if you're a property owner, you've sold your original property, purchased your replacement property, you filed a Proposition 19 base year value transfer claim with our office to take advantage of this program, and you're waiting for us to complete the review of your claim, you may also want to file one of these SB 989 claim forms. And essentially, it allows the tax collector's office to defer your taxes until we have made a determination on that claim, whether it's a denial or an approval. So that may help you if you've basically received a tax bill at the market value purchase price that you purchased the property at. So very important. So that was, believe it or not, the good news. A lot of information, but that was the good news. Now we're moving on to what I like to call the good, or the bad and the ugly of Proposition 19. And you'll see why if you don't already know. I heard some laughs, so I take it that there's it's coming. So intergenerational transfers. This refers to transfers between parents and children, and in some cases, transfers between grandparents and grandchildren. So like I said, this particular benefit was downsized under Proposition 19. Under the old law, basically you could transfer your principal residence and up to $1 million in other property to your children. We'll talk in terms of parent-child transfers to make this simpler. A parent could transfer their principal residence and up to $1 million in additional property to their children without a reassessment. Now they can only do that with the principal residence. So vacation homes, income property, that's going to be reassessed at market value when mom and dad transfer that over. There's additional requirements. So under Proposition 19, the child that inherits or receives the property from their parent, they have to move into the property within 1 year and file either a homeowner's exemption or a disabled veteran's exemption, whichever applies to them within 1 year of the transfer. There are certain circumstances where if they file that claim afterwards, they can get prospective relief, but the important part is they move in within 1 year of the transfer. And they will have to live in that property as long as they want to hold on to mom and dad's tax base. So a lot of new requirements and a lot of reductions. So with all that bad news, there is a little bit more.
Okay.
So like I said, under Proposition 58-193, the old law, mom and dad could pass down their principal residence to their kids. It didn't matter if their property was worth $100,000, $10 million. No reassessment. Proposition 19 places a cap on the value that they can hand down, even when it applies to their principal residence. So the basic kind of rule of thumb is if the market value of that principal residence is $1 million or less at the time of the transfer, there won't be any reassessment. So basically, in those circumstances, the same as the old law, Prop 58-193. However, if the market value at the time of the parent-child transfer is over $1 million, we have to go into what we call a value comparison test. And essentially what it is the child is going to have moving forward as their tax base the greater of two figures, either mom and dad's tax base or the market value less $1 million. So whichever of those two is greater, that's what the child is going to have as their tax base. Now, you'll see down here at the bottom, no SB 989 equivalent. So like I said before, under the base year value transfer program, there is a tax deferment program. Unfortunately, for the intergenerational transfers, even though we do have a backlog with those claims as well, there is no deferment program. So it's going to be important that if a property owner knows that they are going to be applying for this program, they're going to want to file all that paperwork right away because there is a backlog and we won't be able to put a hold on their taxes while we're reviewing their claim. So I know that's a lot of information. We went over a lot of calculation information, but we have a dedicated Proposition 19 web page on the Assessor's website. So we have general information, everything that we went over today, some fact sheets. So it kind of compresses everything onto some printouts that you can provide to your clients if they're looking at taking advantage of either of these programs. All the forms that they would need to fill it out. And the thing that I think is the most helpful, whether you're already engaged in this or you're planning to take advantage of this in the future, are our Prop 19 calculators. So basically, we have one for the parent-child exclusion. We have one for the base year value transfer program. You enter the assessor identification number or the street address along with some market value information. You hit estimate, and that will give you an idea of what the property owner can expect as their tax base moving forward into the future. So I touched on this when we talked about both these programs, but the homeowner's exemption, especially in connection with the parent-child transfer. If you are a child receiving your parent's property, you're going to have to file the homeowner's exemption if you want to qualify for the Prop 19 benefit. Essentially, it's available to all homeowners, though. If you own and occupy your property, you can file the homeowner's exemption. There's no fee associated with it. Once it's applied to your property, it will stay with the property as long as you own it until you sell it or you decide to remove it. What's the benefit? It's $7,000 off your taxable or your assessed value. So that's not $7,000 off your taxes, it's $70. But, and this at this time, $70, any tax savings is a benefit. So if your clients don't already have this on their property, they can look it up on our property search function on our webpage, but I encourage you to have them take advantage of this. So a lot of people do know about the parent-child exclusion. Sometimes they don't know about a related topic, what to do when a property owner passes away, because oftentimes that's how property goes from parents to children. So when a property owner passes away, a parent or otherwise, that death of a property owner is required to be reported to our office within 150 days of that property owner passing away. So the way that one would do that is they would fill out a change of ownership statement, death of real property owner, send that in along with the death certificate, and if it's in a trust, a copy of the trust. That will allow our office to adjust our ownership records, and if it requires reassessment, we can go ahead and do that as well. So this form should be submitted to our office whether the property is held in a trust, it's held in the property owner's individual capacity, there's a will, no will, the property is in probate, whatever the case may be, this should be submitted to our office. Now, as the attorneys know in the room, this is not legal advice, but just some information on trusts. So as far as property held in trust, oftentimes we'll get people will say, oh, there was no change in ownership when my parents died. Their property is owned by my mom and dad's trust. So the best way I can explain it is trusts themselves do not own property. The way I like to explain it is trusts are best viewed as a lens through which property ownership is held. So when mom and dad own their property in trust, they're the owners of the property. When they pass away, of course, they can't own the property anymore. So it's the beneficiaries, usually their children, that become the owners of the property, but through the trust. So again, whether or not the property is held in trust, when mom and dad pass away, the children, who oftentimes become the successor trustees, should consider themselves responsible for filing the paperwork that we talked about on the last slide. And the reason that prompt reporting is important is because it allows us to update our records on time, but it also prevents back tax bills from being issued all at once in the future. So say, for example, you have mom and dad, they pass away in 2010, if property is held in trust, kids don't report this to us. They don't know, or whatever the case may be, they decide to sell it in 2023. We're going to find out that mom and dad passed away, there was a change in ownership in 2010, and we're going to have to reassess all the way back to 2010. So the kids may receive up to 8 years in back tax bills. All those bills go out at once, and unfortunately, the way the law is written, all those bills are going to be due at once too. So that, depending on when mom and dad purchased the property, that could be thousands and thousands of dollars. So prompt reporting, it's not just because we want to reassess you right away. We just want to make sure you're paying the right amount in taxes at the right time, and you don't get hit with these back taxes. So very important word.